Today we are announcing that the California Department of Justice has forged an agreement to strengthen privacy protections for millions of mobile app users in California and throughout the world. The benefits of this agreement will be for mobile app users everywhere, and this agreement is the result of work that we have done in convening the six largest platforms around what needs to happen to ensure that the consumers of mobile apps have increased and heightened protections as it relates to their private information. Essentially, what we did is back in August of last year, we reached out to the six leading mobile app companies. They collectively represent over 95% of the market. They are Amazon, Apple, Google, Hewlett-Packard, Microsoft, and Research in Motion, also known as BlackBerry. And over the course of these last 6 months, we have discussed the need to enforce California's law, privacy law, which is one of the strongest and most explicit in the country. After all, it's actually in the California Constitution. And to do the work of ensuring that the consumers who are using these applications have the benefit of knowledge and then the tools to protect themselves. What we all know is that technology is everywhere. The benefits of technology are everywhere. And what we also know is that most consumers of this technology, this beautiful technology that was created right here in our state, most consumers don't necessarily understand the expanse and the breadth and depth of its uses and applications. And so what we know is that we have populations who, without knowledge of its potential uses, are potentially vulnerable. What we seek to do with this agreement is deal with that issue, which is one, giving more information to the consumer so they understand how this technology can be used and how their personal and private information can be used and potentially manipulated. We also seek to not only give them the information, but to give them tools to be able to protect themselves. And three, give them control so that they can make the decision about what they want to share and with whom they'll share it. The agreement requires compliance with four principles. They are: one, that California law requiring privacy policies does apply to mobile apps. Two, that there must be transparency about privacy policies. And so what we have done is basically agreed that there will be a redesign of app stores and markets to display privacy policies in those stores. Three, there is an agreement on the principle that there needs to be an increase in the awareness by app developers of their responsibilities to protect privacy and their legal obligations thereto. Four, there is an agreement to the principle that there must be corporate responsibility and enforcement for non-compliance of privacy policies. What we know is smartphones are everywhere, and they are rich in data. And so our concern is that consumers don't realize that in their phone, they have their own information about their email address, their telephone number, their home address. And if they have a contact book with the information of all of their friends and family, that information about them is there as well. What we know is that there are apps that, once downloaded by the consumer, will also in turn download the consumer's contact book. I would suggest to you most consumers don't necessarily want that to happen and certainly don't know what's happening. Part of what we seek to do with these privacy policies is give the consumer that kind of information so they understand what may be at risk, and require the app developer to inform the consumer about what information they're going to take from the consumer when that user downloads that app, be it Angry Birds or NASA. What we are also doing is realizing that when you look at the apps that exist in the market today, we've got about 1 million apps available right now in the market. And since 2008, 35 billion times consumers have downloaded those apps. We also know that most mobile apps make no effort to inform users about how personally identifiable information is collected, used, and/or shared. We know that 22 of the top 30 apps, in fact, those most often used, lack a privacy policy. So we believe, and it is part of our perspective, that the consumer should know what privacy information is collected, how it is used, and with whom it is shared. California, in 2004, passed the California Online Privacy Protection Act. It was the first law in the United States requiring online privacy policies. And essentially what this agreement will do is require those who collect personal information to let people know what they're doing with that information. We know that there are approximately 50,000 different app developers in the market today. This agreement will require them to give information to the consumer about how any personal information will be used. And it's important also to realize that California's very tough rules against invasion of privacy are in the Constitution of the state of California, and that those